All right, seeing none, we'll bring it back to the committee. I'm a little perplexed at the shall versus may, because the shall becomes prescriptive. The may actually gives the supervisor, gives Dogger some flexibility, because I think that was what was intended here, was to look at the situation and utilize some or all of the factors rather than being so prescriptive. And so the fact that it goes to may really gives the benefit of the situation. And so that, you know, in the statutory construction, and I think this is a committee where we're used to dealing with those kinds of constructions, that change was something that made sense to me. And this notion of going from 0 to 60, it's been, yeah, maybe that seems rapid at this point, but the fact is that there have been and Dogger has some examples where there was a violator, and the violator was making a business decision to violate. And you can't blame them for doing that when the penalties are so low versus the economic impact of making the change that they had to in the time frame that they were given. Of course, they're going to take the path that provides the least amount of cost to them. That might be violating. What I think the intent here is to raise that level so that you don't have any operator that's making a legitimate business decision to say, I'll take the fines versus changing my system or doing something different in order to incentivize the right kind of behavior. I mean, this legislature has done some administrative penalties fairly recently. There was a lot of hue and cry that was raised over that about, oh my gosh, the sky will fall, all these penalties are going to come down. And in fact, that agency has yet to issue a penalty, but yet all the violations have been cleaned up, because what we did was shift that balance to the prospect of such a high fine that it affected the behavior. I think that's what's going on here. Now, the notion of graduating or building in some kind of a structure there is interesting. Personally, I'm not necessarily opposed to that. I think that's something that the author and Dogger would have to work through. But again, I think for me and what we've tried to look at for this bill is providing the right incentives for the right behavior. That's ideally what an agency does in its fine structure to make sure that we're getting the results we do. And then when you have an egregious violator, somebody that is just doing what they're doing and gets caught at it, you know, they will be fined, and the fine then should be substantial. Okay. So did you want to?
Yeah, just comment on that real quick. I think the second part we agree with exactly what you said, but let's go back to the words. You're making a point, but I think you might have the language flipped, because it shall consider. That means he shall consider a mitigating factor, and if he decides that mitigating factor isn't substantial enough to lower the fee, it can then be dismissed. Okay. If you say may consider, okay, then doesn't have to consider it at all. It never. So I don't see how we're limiting flexibility. While may gives you more or less. Shall consider, they can consider it and then they can reject it. May consider they don't have to consider it at all.
Right, but which is why there actually are a lot of ordinances and statutes that will say in the definitions, shall means may means shall, because we get into these semantic fights. I think this is one of those semantic circles, because whether the person who is potentially levying the fine shall consider and says, I considered and didn't, or may consider, they're still potentially in that same role. What we wanted, the importance is enumerating the list, enumerating the kinds of situations that we want the fine to be based on, because they also have a responsibility, since that's been laid out in the statute, to justify the fine within the context of the statute. And so whether we say may, whether we say shall, I think in this context, by saying may consider, we're elucidating what we expect. We as the legislature, since we're putting this forward as a statutory provision, we're saying this is what we want you to be considering, and whether it's you will have to consider the entire list, part of the list, we're trying to build in some discretion so that the severity of the issue, which then plays into your concern that maybe there's a graduation, maybe there's some other, that's something I think to work out with, again, with the author and with Dogger as that moves forward. But the construction of the statute, we're trying to make sure that we build in that level of discretion so that the right conversation that can then be ultimately matched. If you do come up with a graduated enforcement or a graduated set of penalties, then it more readily becomes matched up to those. Mr. Thurman?
Thank you, Mr. Chair. I would say that you have accurately described what our intent was in using the May language to give some discretion. But to avoid ending up in a circular argument, we'd be happy to work with the opposition on moving to a language that says shall. As for the tiers, again, Mr. Chair, I think you've been very clear in stating what we're trying to do here is to create incentives to say that when there is an incident, it needs to be resolved quickly. I think that the fines as proposed does that well, and but we'd be willing to work with the opposition around the language of moving from may to shall.
Okay. Well, I guess as I read statutes, that sort of removes discretion, which I thought was working against what you wanted to do. But maybe the more important issue is working through the graduated fine process. Mr. Wagner?
Thank you. I typically read shall to be the mandatory. You shall consider X, Y, Z as laid out in the statute, and may to be permissive. That's how we've written statutes all the time. And you know, my understanding of the directory nature of shall is, I think, what the opponents are looking at as maybe one way they can remove one of these due process concerns that have arisen. And I am encouraged to hear the opposition suggest there might be ways to solve it. I am perplexed at the opposition's statement that they have no concern about this director or this supervisor, because frankly I heard from this director one of the most chilling things I've heard in my 6 years up here from a government employee. Oh, there's a little thing about due process out there, and and the hand gets waved, and this little thing like due process, as if it doesn't matter. And that's fundamental. That's in our founding documents and has been what should govern the conduct of any government or any regulatory agency in a government in any state in this nation. To have it cavalierly disregarded like that is extraordinarily troublesome. And I would say if you think you can work out due process problems, good luck. I think you've got your work cut out for you given the attitude. And that's one of the reasons why I am opposed to the bill and opposed to the idea of allowing this government agency to have a whole laundry list of issues that it may consider but doesn't have to, when we have said in our statutes these are things that are important to consider. So I can't get there with this bill today. I can't get there with this attitude with respect to due process. And I wish you guys all the luck in the world in getting there. I know to my core that this is not a cavalier attitude towards due process from this author.
Chairman,
it's from the government itself, and that's unfortunate.
Mr. Wagner, let me clarify my
Hold on,
statement. Chairman?
There's no question in there. We're going to move to Mr. Gallagher.
Yeah, I just had a couple questions. One is for the opposition, and one would be for the author. But with regard to the opposition, so I guess my interaction with this has been more at local government, and I recall that a local government in my district on their wastewater treatment plant, when it was not meeting requirements, they were subject to a $25,000 per day penalty. And I'm wondering if that's the case for municipalities when they have a discharge into an illegal discharge, why shouldn't it mirror what we're doing on the with the Water Resources Control Board? Why shouldn't the civil penalties mirror what we're doing there? Basically, treat everybody the same.
Yeah. Mr. Gallagher, we're not suggesting that we shouldn't in that situation. Don't know all the facts, but it sounds like that was an imminent threat to human health and safety. We're not saying that there shouldn't be penalties that deter violators from deterring those type of violations, and that's the highest one you can do is $25,000. We're saying there should be another step below that. If it does not, or it may reasonably result in a threat to human health and safety, not an imminent threat, but may, then that should be a little lower. If it's a paperwork violation, that should be something even less than that, an administrative civil penalty, not the discretion to go up to $25,000 That's what we're concerned about.
And that was
Can
a
anybody
question that was
speak-
also directed to Dogger.
Right, and can anybody speak to, is that how, like, Water Resources
That's how
Control
Cal OSHA
Board,
does it.
for instance, does it?
Cal OSHA, yes, they have.
That's how Cal OSHA did. Can anybody speak to some of the other agencies at all? Like, is it the same way that they do it?
So on oil spills, oil spills, that's how Fish and Game does it, based on the severity and willful intent.
I don't have anything else to add. We're generally making our law more consistent with laws. I mean, the provisions in the Air Board and Water Board and others. I mean, you probably can find various variations in state law how these are applied. Again, the concept of trying to make the violation fit, the penalty fit the violation, I think we pretty much all agree with that. I mean, so there's room to talk about how that's structured. If I could have a moment, I'd love to respond to the comment.
Only if you're asked.
Okay.
So, I mean, to that point, I just think, like, things should be even-handed. Like, if one agency, all the agencies should sort of be doing this the same way. Obviously, there's going to be some variation, but it shouldn't be that significant. I think there's a point to uniformity, right? So that we're doing the same thing in similar circumstances. My question, though, for the authors and maybe for those who are in support is, what if you're wrong? What if the agency's wrong? And I think agencies are wrong, and they're wrong more often than I think we would like to admit. And I've had constituents where, they get some sort of penalty or some sort of, claim against them, only to later find out on appeal that actually they weren't in violation, and they can't get attorney's fees back. They can't get any there's no recourse when the agency's wrong. And one of my problems with this bill is it's taking away at least, one of the areas of recourse that I'm even aware of in government right now, where if Dogger's wrong and it gets overturned on appeal, they can get recovery of some costs.
Okay.
And to me, I think that's the way it really should be. Is if an agency's wrong and it costs somebody money, shouldn't it work both ways? I mean, if somebody's polluting, they need to pay, right? And they need to pay the fine, and they do something wrong. But if the agency's wrong and they cost people significant sums of money, and they prove that the agency was wrong and they acted arbitrarily and capriciously, for example, should not there be some recovery? So why are we eliminating that in this bill? To me, that's a big problem. It's got to work both ways. Otherwise, it's not even-handed.
No, thank you for the question. My read of the bill is that it really is intended to be reasonable, and to say that when there are situations that are emergency, that actions should cease and desist. When there are other situations where an investigation needs to take place, that investigation can take place. And if that investigation is unfounded, that there are some provisions to help that operator recover some loss if there needed to be a stay of action. And I say that to say that I appreciate your question, Mr. Gallagher. I appreciate the spirit of what you raised, Mr. Wagner, that in fact, yes, I agree that due process is important. And I think that this is a measure that attempts to find balance, to respect due process considerations, but to protect public safety, and to say that there are times when we need to intervene quickly and to create incentives or disincentives to make sure that operators move quickly to resolve public safety issues.
Well, to kind of help with that balance, would you consider taking out the provisions in this bill that I think are problematic for due process concerns? One would be the ability to get recourse if in fact the order was wrong, and two, the ability to record proceedings, because I think we all have a right as citizens. Mm-hmm. If we go into a hearing, we should be able to record that hearing and make sure that everything was done. And that's in some ways that might be the only way for us to prove that something was done wrong. That helps protect due process. Would you consider maybe modifying or removing those provisions from this bill?
We've had conversations about why multiple recordings could create challenges. And so, again, I think this bill attempts to be very reasonable in its approach. And we've heard today the most opposition is to the permissive term may versus what I consider more prescriptive shall. And again, we're prepared to work with the opposition to move towards shall. If that will create a sense that there will be fairness and equity in how this is applied, that it speaks to the spirit of due process, then we think that's a reasonable conversation. I want to yield some time to the department for some additional emphasis.
Hang on. If asked a question, this is not really a free-for-all. I just want to make sure that there's a question asked to the department or to the author. So what is it that you'd like to hear from the department on?
If I was going to add to his response to Mr. Gallagher's question.
Through the chair, if that's permissible.
Okay.
Thank you, sir.
There's two things you raised, Mr. Oh, I'm Ben Turner with the Department of Conservation. There's two issues you raised there with respect to the recording. So in the way the statute is currently written, it says it's going to be recorded by a stenographer, and the operator may have a recording device as well. So there will be an official record created by a stenographer during the administrative hearing process, and then the way it was, it created an audio recording of equivalent weight to the stenographer's recording. If, for example, the opposition were interested in emulating California courts rules where you can record, and I don't believe this bill would prevent this. If an operator came in and said, hey, can I record this for my personal notes so that I'll have a record, then that would be fine. And then the California courts rules allow to record if the judge approves, but it's not for the creation of a record that can be used as a basis for an appeal or anything. That's the stenographer, the official record of the hearing. But you can use it for recording. So I want to remember what he said, and then we can develop responses to that and so forth. But having a situation where there's both an official record and a recording would make it such that you could have a dispute over what happened in that hearing. Especially, I'm not saying that the operator may or may not do this. You can modify recordings. It's easily on most laptops with basic software that comes with them. So you can't have those used as the record in an appeal. So that's the issue. If someone wants to record for their personal notes, that would be fine. The second issue you raised is regard to the recouping your costs in the event of an order having you make expenditures with reasonable work. Yeah, exactly. So there was a court case in 1990, Yuba Natural Resources versus the United States, that says that lost profits are not reasonable work associated with this. So all we're doing there is stating existing law, because we've had operators threaten to sue over lost profits or engage in litigation. It was just a waste of our time and their time, given the existing case law on that matter. So we're not taking away operators' ability to recover costs that's not prohibited by current law with that change. That's a clarification of existing law.
Well, and I'm not familiar with that exact case, but my point is, it should be even-handed, right? I mean, if it's proven that a regulatory body is wrongfully acted, mm-hmm. is the person just left? Hey, sorry, whereas if the shoe was on the other foot and they were in violation, they're going to pay to the fullest extent of the law. I mean, I just feel like this is a big problem. It's across the board. It's not just this instance. But, when regulators or the government is wrong, there seems to be no recourse. There's no compensation for the person who had a wrongful order against them. But when on the other side, $25,000 per day plus whatever else is going to be recovered, right? I mean,
and to the extent that that's a bigger question of, as you said, maybe there's a bigger question in all other agencies. We're just dealing with this one situation, which is trying to align with other agencies. And of course, there are recourses. If there is a fine, if there's an action taken by an agency, then an aggrieved party can always go to court to set aside that action, overturn that action, and even potentially raise the issue of a takings, depending on what the circumstances were. So there are some checks and balances that are put in place, and in fact, the statute, the bill here does propose some of those mechanisms to be able to have a bit of process around that if there is a problem or was a mistake that was made by the department in trying to enforce it. So I think a lot of that has really been addressed in the bill that's before us today.
Mr. Chairman, may I, at the risk of prolonging the hearing, but in asking the indulgence of the chair, I do believe, in fairness, the gentleman from Dogger does deserve an opportunity to respond.
Yeah,
I did not.
I agree. I was going to ask if nobody else asked. You said that you didn't.
I didn't have a question.
That wasn't a question.
But he did. I think he deserves the opportunity to respond.
No, all right. Well, let's go to Mr. Holden, and then, Director, I'm going to ask that question about that. That was a pretty serious statement, especially with respect to due process, and I would like you to address that issue, your perspective of due process within your agency. But let's get Mr. Holden first, and then I'm going to come back to that.
Thank you. Mr. Chairman, I don't necessarily have a question per se. I certainly want to thank the author for his attempt at looking at ways to reform Dogger, to try to find ways for it to become more efficient and responsive. I will say that I came in questioning the need to give the agency more power when it wasn't clear that they were utilizing that power that they existently have. Concern about how they were cited by the federal government for not protecting our water at one point, and it certainly led to legislation that said we need to do a better job. And so there's an agency here that I was looking at and thinking, hey, you know what? There needs to be some reform. Some of it may have been expressed in the comments today. Understanding further that under SB 4 there was a need to start looking at some type of fine and some type of structure associated with that. So I was a little bit concerned, still am. But I will say that the conversation has been helpful. The opposition has indicated a desire to work with you to try to drill down on this area of how the fines are identified. And to be honest with you, I think that where the focus seemed to be on the economic size of the violator versus the actual harm that was being done, that was a concern. And you're open to continuing to have conversations around those types of things. I know it moves to appropriations. I'm on appropriations. I look forward to having an opportunity to review it when it comes before that fiscal body, even though these are policy issues that we're calling out today. So I will take all of you at your word that this is something that is fixable and that there's an effort on both parties' part to try to find that solution. So I will move from staying off the bill to being supportive of it to help it move forward, to give you that opportunity to iron out the wrinkles.
Thank you. All right, Director, and when we talked quite a bit about due process and going through the issues of this bill. So I would like you to respond to Mr. Wagner's concerns about any conversation that you had, but the agency's respect for due process and what you're trying to do in this bill.
Thank you for the opportunity to clarify my statement. So my statement I was trying to make was that the changes to due process we thought were not the big significant issues. There's thorough due process, and we strongly support that. We not only have an appeal process within the department, you also can take these same issues and appeal them to the administrative law hearing. In addition to that, you can go to court. So in fact, for our department, there's actually 2 appeal processes before you even have to go to court. We fully support all of that. So I'm a big advocate of due process, and that is not frivolous. What I was trying to point out is I thought some of the amendments that were being proposed to it were trying to be over-exaggerated, that somehow there wasn't due process when in fact there is extensive due process. So I apologize for the confusion of my statement.
Thank you for the clarification.
Thank you. Other questions from committee members? All right. Seeing none, Mr. Thurman, you may close.
Thank you, Mr. Chair, and thank you to the members of the committee for this opportunity to have rigorous discussion about how we protect our communities and at the same time respect the rights of operators and due process. You've given us good insight, and we're looking forward to moving forward to working on some of the minor changes that were recommended here today, and I would respectfully ask for your aye vote.
Thank you. The recommendation is due pass to appropriations. I'm still looking for a motion. We have a motion. Is there a second? And a second from Mr. Ting and Mr. Chu. Call the roll, please.
Stone.
Aye.
Stone, aye. Wagner.
Not voting.
Alejo. Chow. Chow, aye. Chu. Chu, aye. Gallagher.
I'm a no today, but I mean, we can work on some of those issues.
Gallagher, no. Garcia. Holden. Holden, aye. Mainshine. Ting. Ting, aye.
That needs one more vote to get out. So we have one absent member. If we can get Ms. Garcia here, and then, Mr. Mainshine. So we do have two absent members. So Sergeant could get the absent members in, and if you've voted on all the bills, you're free to go. Could you call the roll for the absent members? I think we still need to go through the number of the bills for Mr. Alejo. So for consent agenda, and we also moved item number 3, AB 2249, Mr. Cooley, to the consent agenda.
Alejo. Alejo, aye. Item 1.
Item 1 is AB 2178, Mr. Chu's bill.
Alejo. Alejo, aye.
Item 2 is AB 2244, Mr. Gatto.
Alejo. Alejo, aye.
Item number 4 was pulled. Item number 5, AB 2611, Mr. Lowe.
Alejo. Alejo, aye.
And then item number 7, AB 2853, Mr. Gatto's second bill.
Alejo. Alejo, aye.
Okay. So we'll hold the roll open for a few more minutes if we can get Ms. Garcia and Mr. Mainshine here. Okay, so item. Okay, so the final bill that we have, the bill that is on call, is item number 6, AB 2756. Mr. Thurman, call the absent members.
Alejo, Garcia,
I'm going to vote aye, but if you can continue to work on the May,
Thurman bill.
shall, yeah. Is it, we're doing the
Garcia, aye. Mainshine? No. Mainshine, no. Aye as well. Alejo, aye.
So, Mr. Thurman, that bill is out. We have completed business for today. Thank you, members. And we are, and for those members who are still here, we are probably going to be starting next week at 8:30 in the morning. We have a very busy agenda. And with that, we are adjourned.